Hearing the appeal, Hartley and others against King Edward VI College.
Yes, Mr. Stephen.
My lady, my lords, good morning. I appear with my learned friend Catherine Newton for the appellant, my learned friends Mr. Thomas Linden, Queen's Counsel, and Mr. Ben Cooper appear for the respondent. My lady, my learned friend Mr. Linden raised with me just before the court sat how the court would wish to deal with the respondent's application to argue its new case, particularly since we're quite short on time.
Yes, you are short on time, which is always a good thing. Greatly improves the quality of counsel's submissions if they're short on time. We have discussed it, and subject to being persuaded to the contrary, we thought the sensible thing to do was for you to argue your case on the 1870 Act, and then for Mr. Linden to persuade us that we should listen to his case about that and give you plenty of time to respond to his case, which we probably will let him argue.
My lady, I'm grateful.
Is that all right?
Yeah, so, my lady, we take as read then, do we, the submissions made by both parties as to whether permission should be granted to argue that new case or not?
We don't like deciding cases on an artificial basis. And if there's a knockout blow or a solution, for most of us, speaking certainly for myself, I would rather deal with the case properly rather than on an artificial basis. But
this appeal does raise a fundamental point of principle for teachers in secondary education.
is it only teachers? Isn't it relevant to almost anybody employed?
The respondents...
In a professional capacity, at least. And what about judges?
My lady, it would almost certainly raise the same fundamental point of principle for judges. Indeed, if my learned friend's new argument is correct, the ramifications of the decision in this appeal may be very wide indeed. I am representing teachers today, and that's why I began by saying that for my clients it raises a fundamental point of principle. It is peculiar, perhaps, to teachers in that the principle that really brings us here is whether their jobs are to be regarded as confined to the hours of 9 to 4:30, Monday to Friday, including an hour off for lunch, or whether they extend far beyond those hours. And the answer to that is so clear, one might say notorious, that it seems odd we should have to ask it. 32 years ago, the position was analysed by Mr. Justice Scott, as he then was, after hearing oral evidence in the case of Sim, which is in your core bundle of authorities at tab 14. And I wonder if I might just take the court to a few of the passages in that case. It involved, like this case, teachers who had taken industrial action, and the plaintiffs argued in that case that one couldn't subdivide a teacher's contractual duties by function or time, so that the Apportionment Act must apply. As I say, it's at tab 14, and if I can just initially take the court to page 903, internally 610, bottom right.
So is it 610 in the electronic?
It is, my lady. Shall I always use the electronic bundle page numbers? Is that
As long as the hard copy is also numbered with the electronic ones.
It is.
Well then, yes, please do.
So, my lady, at 610 within the submissions on behalf of the plaintiffs in that case, just below F, I read, it is self-evident from the nature of the teacher's contract providing for payment on a monthly basis that the doctrine of entire contract does not apply, but that the Apportionment Act applies. The teacher's salary accrues day by day. There is no allocation under the contract of specific amounts for specific duties. Even if deductions were permissible, they did not take account of the fact that teachers have to work for more hours per day than is provided for in the timetable. Not only is a teacher's salary not divisible according to function, it is equally not divisible into periods. And Mr. Justice Scott dealt with the plaintiff's professional duties initially at page 635. between F and G, in considering the scope of a teacher's professional obligations as a teacher, it is convenient to start with those matters that are common ground. It is accepted that the teachers have an obligation to teach their classes in accordance with the timetable from time to time in force. It is accepted that they have obligations properly to prepare for their classes and to mark the schoolwork done by their pupils, either in class or as homework. It is accepted that these latter obligations may require work to be done outside normal school hours.
Very like a judge, really.
Very like a judge. To put the point another way, a teacher could not excuse a failure to be properly prepared for a class, or a failure to mark schoolwork within a reasonable time after it had been done, by pointing out, correct though the observation might be, that he or she had not had time within school hours to do the work. It is perhaps one of the hallmarks of professional employment, as opposed to employment in non-professional capacities, that professionals are employed to provide a particular service and have a contractual obligation to do so properly. A worker in a car factory or a shop may clock off at 5:30 or perhaps work late on an overtime basis. An employed professional does not usually have an overtime option. He's employed to provide a particular service to proper professional standards. His contract may require his attendance in an office or other place of work for particular hours, but his contractual obligations are not necessarily limited to work done within those hours. So too, teachers' duties are not necessarily confined to their obligation to be on school premises during school hours and to take their classes during those hours. The judge then went on to discuss the other professional obligations of a teacher in the next paragraph that one might characterise, indeed they are characterised in the appellant's contracts as their non-teaching duties. In order to avoid having to return to this authority, can I then turn to the passage in which Mr. Justice Scott dealt with the consequences of that contractual analysis for the applicability of the Apportionment Act? That's at page 642. Just above G, Mr. Gowdy submitted that the real question was whether a teacher was entitled to be paid for the period of 35 minutes that he or she had not worked. Pay for that period, he said, had not been earned. In my judgment, this approach is fallacious. It involves regarding the teacher's salaries as accruing minute by minute. There is no legal or factual justification for that view of the salaries. Under the contracts, the salaries are based on a yearly scale, but are paid by monthly payments. Each month, the contractual right to a salary payment vests in the teacher. By reason of Section 2 of the Act, the salaries are deemed to accrue day by day. If a teacher's contract were in the middle of a month to come to an end by death, dismissal or some other event, Section 2 would entitle the teacher or his estate to an apportioned part of the month's salary payment. So the salaries may be regarded as accruing day by day, but they do not accrue minute by minute. And for as long as the contract is continuing, the only payment that can be claimed by a teacher is a monthly payment, and the only obligation to make a payment of salary that rests on the Education Authority is an obligation to make a monthly payment. The duties of a teacher at secondary level and the time demands of those duties were considered again by the courts 13 years ago in the case of Smith, which is at the very next tab in the hard copy bundle. In that case, there was a contractual term that in the event of a day's strike action, salary would be deducted at the rate of 1/365. One sees that at page 654, paragraph 6. The employer contended that that term was inconsistent with the applicable statutory scheme, which is in almost identical terms to the current statutory scheme set out at paras 20 to 22 of the Red Book and incorporated into the appellant's contracts. One sees that at paragraph 9. Those indented paragraphs are pretty much identical to paragraphs 20 to 22 of the Red Book. The employer argued that the teacher's role should be seen as essentially to perform what they referred to as the 195-day obligation. One sees that at paragraph 20. Ms. Smith argued that her essential duties included also those duties performed in her, what we now call, undirected time. And in support of that, she provided evidence, which is cited at paragraph 21, that in 2004, a teacher's working week was commonly 50 to 60 hours, not infrequently 70, and much work had to be done at weekends and during holidays. That is to say that with the time for performing their directed duties limited to 32.5 hours a week during term, teachers were spending between 35% and 53% of their working time performing their professional duties during undirected time, leaving aside holidays. And as we noted in the Court of Appeal, that would mean that the ratio of total working time, 50 to 70 hours, to directed time, 32.5 hours, is actually similar to the ratio of calendar days, 365, to directed time days, 195. And one notes considerably higher than the ratio of calendar days to the 260 Mondays to Fridays in a year. In other words, and it's worth perhaps pausing to reflect on this, if one were to calculate from first principles the appropriate deduction for a day of missed directed time with no corresponding avoidance of undirected time, one would arrive at something like 1/365. Mr. Justice Mackay records Ms. Smith's analysis of that evidence regarding the propriety of the contractual term as to the level of salary deduction for a day's strike at paragraph 22. Can I read from the last couple of lines on page 659? What has been achieved in the Burgundy book is a compromise solution acceptable to employers and employees. Were it not to be part of the contract, obvious arguments would take place between employers and employees as to whether the bare 195 days, as here, would be the right measure to quantify the entitlement to deduct, or whether some additional, and if so, what allowance should be made for the extra duties to reach the figure giving the true value of a teacher's working day lost by strike action. The question is not straightforward, and the arguments of the defendant are powerful and coherently deployed, but in my judgment, the claimant's argument prevails. The position as...
Mr. Siegel, presumably the Burgundy book and the Red book come out of the same stable, as it were.
Absolutely, my lord. And
what is the perceived explanation for an absence in the Red book of anything equivalent to section 3.2 in the Burgundy book?
My lord, as my lord might imagine, we have looked into that question. I'm afraid I can't assist the court any further. It just was that the different collective negotiating body responsible for those whose terms are governed by the Burgundy book addressed their minds to this and came up with the solution. The negotiating body responsible for the Red book either didn't address their minds to it or they did and couldn't agree on anything. I'm afraid I don't know. The position has not improved since in terms of teachers' workload. As we note in our printed case, the 2015 report of the Independent School Teachers Review Body cited evidence that untimetabled workload had become such an issue that up to 3/4 of newly qualified teachers considered leaving the profession because of it. In this case, the appellants themselves have given evidence as to their individual positions consistent with that picture, and for convenience, that evidence is summarised in the agreed facts, that's within the core bundle at page 43. I won't weary the court by reading it out, but if the court could perhaps just read that.
Which paragraph?
2.4, my lord, on page 43. It's introduced by the words that the appellants regularly perform their undirected time duties outside of normal term time hours, weekends, evenings, days of annual leave. These are agreed facts, not contentious.
This isn't contentious, is it?
No. And as I say, my lady, my lords might want to just glance over very quickly what each individual says. But as my lady points out, it's not contentious. So
Well, some of us come from families of teachers.
I do. Mother and a sister. The answer then to that question of principle, which is so important to teachers, is that their essential professional duties obviously extend far beyond 32.5 hours a week term time. So how are those duties dealt with in the contract? Mr. Monk's contract is within the appendix in the core bundle at page 203. Save for, in one respect, which I'll turn to later, the contracts are materially the same. Starting, if I may, with the salary provisions probably the most important, at the next page, 204, paragraph 4. He's paid an annual amount, monthly in arrears, every month, for the performance of his current, what are referred to in 4.4 as duties and responsibilities. What are they? At clause 1, if we go back, there is a heading, duties. You will carry out your duties under the reasonable direction of the college, etc. They are, as one sees, compendiously described here. There's no distinction between those performed in directed and undirected time. 1.2, though, tells us where to find the detail. Any of the duties set out in Appendix 4, that's what he can be asked to perform, and then penultimate line in the same paragraph, the tasks specified have to be within the list of duties laid down in Appendix 4. My lady, Appendix 4, we say, together with the salary clause, is the key part of the contract for present purposes. One finds it at page 253, headed professional duties. Again, no distinctions made between duties performed in directed or undirected time, and obviously no implication that some are paid and others unpaid. Instead, the distinction is between what are referred to as teaching duties and other activities. And it is the whole list that is said to be included in their professional duties. One should perhaps spend a little time reading what is said to comprise teaching duties. Mm-hmm. Planning and preparing courses and lessons.
Well, we could read it to ourselves, couldn't we?
Well, Melody, I'm grateful.
We probably already have.
In short, then, it is everything relating to the teaching, not simply the classroom contact time. When are they to be performed? Put another way, how is Mr. Monk's working time to be regulated? If we go back to the contract at page 203, there is a heading, clause 2, working time. This is effectively a summary of the relevant Red Book provisions. There will be 195 days in which he may be required to teach, in addition to carrying out other duties. And at 2.3...
And what's the origin of 195? I mean, why 195?
I think, though I'll stand to be corrected, that for the normal aggregate of term time Mondays to Fridays, you have, well, if I'm right, 49
So it's non-holiday
weeks.
times?
So, no. It's 49 weeks worth of Mondays to Fridays. I'm just doing the calculation in my head, but I think that's the rationale. But 39, I'm sorry, did I say 40? 39, I beg your pardon. So 2.3, in addition, you will work such additional hours, as may be needed to enable you to discharge your duties effectively, including, and this is why I suggested we pause at the definition of teaching duties, including the marking of work, writing of reports, preparation of lessons, etc. Those are all teaching duties. One notes the year means 12 months, and while we're here, so we don't have to turn back to it, details of holiday periods will be made available. You will be paid full salary during these holiday periods, unless you are receiving less than full salary arising from the application of sick pay, maternity schemes, etc. There is a dispute between the parties that may be more relevant to the new case than the old as to whether the appellants are paid for their holidays or simply during their holidays. I just note that at this point.
And which side are you on?
I'm on the paid during, not for. We say that, in fact, if you look into the contract, it's rather obvious that I'm right, but we'll come to that. Those provisions are in more expanded form within the Red Book that I'm sure the court has all looked at. That's page 225, paragraphs 20 to 22. And the additional points to note are simply that in the last sentence of paragraph 20, the balance between teaching and non-teaching duties, this is within directed time, and the length of the teaching day are subject to the reasonable direction of the principal. Teaching duties obviously must mean the same as it does in Appendix 4. So yet again, confirming that within the directed time there are to be both teaching and non-teaching duties performed. And at paragraph 22, one notes again that the duties to be performed in undirected time are no less mandatory. He may be required to work his directed time, he will work his undirected time. Before leaving the contract for the moment, is there...
Mr. Siegel, where are you getting that from, please?
From paragraph 22, the first sentence, my lord, in addition to the requirements in 20 and 21, a teacher will work such reasonable additional hours as may be needed, etc. Page 225, my lord, paragraph 22 under the heading working time.
Right, thank you.
Is there not a bit of a conflict between the requirements of paragraph 20, the balance between teaching and non-teaching duties? Well, you've reminded us what teaching includes, as per Appendix 4, includes assessing, recording and reporting on the development, progress and attainment of students. Okay, that's all teaching duties. And then 22, in addition to paragraph 20, a teacher will work such reasonable hours may be needed to enable them to discharge their duties effectively, including marking. Isn't it rather the same thing coming in twice, Mr. Siegel?
My lord anticipates a central submission that we make and that was to some extent resisted in the Court of Appeal, but is accepted in terms in my learned friend's written case. Absolutely. And we all know this. A teacher who, let's say, is timetabled to teach in the morning but not in the afternoon will typically teach in the morning and mark or prepare lessons in the afternoon. They won't, as we all know, finish that and clock off at 4:30 and then resume work at 9:30 the next morning. They'll go home, finish the marking, prepare the next day's lessons if they haven't finished.
Well, I suppose it all depends how quick they are, really.
Well, it does, but as I said, my lord, there is a body of evidence, putting aside family connections and general notoriety, that would indicate that I present the picture accurately. But in any event, my lord's point is a more straightforward
That is your
one.
central point. It wasn't actually the point I was making, Mr. Siegel, which is there's a bit of duplication here. When paragraph 22 says, in addition to the requirements in paragraph 20, you've got to mark students' work, write reports. They've already included that in paragraph 20 because, of course, teaching under Appendix 4 includes assessing, recording and reporting on the development of students.
Well,
so there's they're tumbling over themselves. That was the rather limited, possibly slightly pedantic point that I was making, Mr. Siegel.
Well, my lord, I would certainly not accuse my lord of being pedantic, but I would suggest that perhaps one needs to stress the words in paragraph 22, such reasonable additional hours as may be needed to, and then perhaps one puts in square brackets, complete
Yes, I see.
the discharge of their
Very well.
duties effectively.
Is it simply that 20 is that whilst you're on the premises,
It is.
the principal can organise your time for you, whereas 22 deals with what you do when you're not on the premises?
Yes, but my lord's point, we reiterate at the risk of wearying the court, it is an important one. It is that all of these duties, except for classroom contact time, are, not just maybe, but are performed, both in directed time and in undirected time.
Clearly anticipated that a teacher will need more than the directed time to complete properly the teacher's duties. That's why there's both 22 and 20.
My lady puts it much more concisely than I. So it's not just the reality of the situation, it is the contractual anticipation or intention. So the last thing I was going to do with the contract for the moment is to explore the question, is there anything which bears on the quantitative split between directed and undirected time? It's common ground that there's bound to be a correlation between the two, and the Court of Appeal found that. Can I just perhaps, whilst were in this bundle, invite the court to look at page 148, because, again, this was common ground. Having read the respondent's new case, I'm not sure it remains so. Paragraph 7, first sentence, the only sentence I'm inviting the court to look at page 148. This is in the Judgment of Lord Justice Elias. There is inevitably a correlation between directed and undirected time. The more directed hours a teacher performs, the more this generates preparation, marking, report writing, and so forth. And that becomes particularly pertinent when we consider the position of someone who is either asked to do, agrees to do more than the standard amount of work in a year, or less than the standard amount of work in a year. Going back to the contract, the only guidance in the contract is at page 313 as to the balance between the two. It's only guidance, but it is jointly agreed, and it's in that italicised paragraph at the bottom of page 313 within Appendix 9 of the Red Book. The new contractual arrangements should be applied so as to ensure that no teacher is allocated an unreasonable total workload. So the school or college in this case is, because it's also Burgundy, but is supposed to have a view of all of what the teacher will have to perform. The continued provision of quality education can only be delivered by teachers if they have adequate time to meet properly all the demands upon them arising from the different elements of their responsibilities. It is the clear intention of the committee that colleges should ensure that in determining the workload of individual teachers, a proper balance is maintained between directed time and undirected time in respect of activities such as marking, preparation, administration, separate from student contact. In determining the amount of actual teaching time which is allocated, consideration needs to be given to the level of work, number of students, additional responsibilities, preparation, marking that accompany the actual teaching load. So, in short, the duties performed during the whole of Mr. Monk's working time are in every way interdependent. So he is paid a salary of $38,000 a year to perform the full range of his professional duties, something like 60 to 70% of which he'll perform during the hours scheduled by the respondent, and about 30 to 40% of which will be performed outside of those hours, at weekends, evenings, during holidays. And as we've seen, everyone...
And there's no overtime, is that right?
Well,
Absolutely no overtime. He can work 140 hours a week. He still gets not one penny more.
well, there isn't any overtime, but at some stage you're going to presumably deal with the allocation of 4 extra
Correct.
days,
My lord, correct.
which is arguably of some significance.
It is, my lord. Both sides rely on it.
Yeah.
And to recall that initial characterisation in SIM, we say, therefore, that under the contract, the duties are clearly not divisible by function. They're not divisible into periods. And one of the more absurd consequences of the respondent's case is that when Mr. Monk begins preparing a lesson during directed time and completes that task during undirected time, the former would have to be considered a core duty, while the latter ancillary. Indeed, on their new case, the former would be paid and the latter would be unpaid. So you're paid for half of the marking and unpaid for the other half. And we respectfully suggest that any contractual construction which reaches that conclusion must be wrong. So how does the law approach the apportionment of such salaries? And the short answer, my lady, is precisely as analysed by Mr. Justice Scott. However, to take matters from first principles, may I invite the court to turn to tab 1 of the Core Authorities bundle, the Act. Short and sweet, one might think. Page 395, first page, preamble. Whereas rents and some other periodical payments are not at common law apportionable in respect of time, and for remedy of some of the mischiefs and inconveniences thereby arising, diverse statutes have been passed. This was not the first Apportionment Act, but it was the first one that expressly included salaries as a type of annuity. Section 2 all rents, annuities, dividends, and other periodical payments in the nature of income shall, like interest on money lent, be considered as accruing from day to day and shall be apportionable in respect of time accordingly. Section 5, for the moment simply over the page at 398, the word annuities includes salaries. And finally, section 7, the provisions of this Act shall not extend to any case in which it is or shall be expressly stipulated that no apportionment shall take place. Now, as regards sections 2 and 5 in particular, the respondent now suggests that matters stood materially differently in 1870 to how they stand today. The respondent is wrong. In 1870, more so than today, a distinction was observed between what were known as white-collar workers, by reference to the dress shirts they used to wear, performing professional admin management work, and blue-collar workers, named for their customary overalls, also known as labourers or workmen, who performed manual and factory work. And broadly, the former were paid salaries, and the latter were paid wages. The relevant historical analysis, drawing on the learned paper of Professor Deakin and the cases that he refers to, is summarised at paragraph 26 of our response to the respondent's new case. I'll simply give you the reference. It's at page 91 of the core bundle. May I just add to that one case within the core bundle of authorities at tab 12? It's the case of Moriarty. It was an appeal to the divisional court. I refer the court to it only because it specifically sought to construe in 1921 salaries in Section 5 of the Apportionment Act. Can I ask the court to turn to page 590? This is within the judgment of Mr. Justice McCarty. Can I pick it up about 7 lines down with a line and a sentence beginning, I take the following definition of salary from the Imperial Dictionary. The recompense or consideration stipulated to be paid to a person periodically for services, usually a fixed sum to be paid by the year, half year, or quarter. When paid at shorter periods, the recompense is usually called pay or wages. Thus, a judge, governor, or teacher receives a salary. A labourer receives wages. That dictionary meaning is in accordance with the judicial view so far as expressed upon the matter. They cite Gordon and Jennings, where the question was as to the meaning of wages in 1870 legislation, coincidentally, in which Mr. Justice Groves said, in the first place, wages is some indication of the object of the Act, for though it might be said to include payment for any services, in general the word salary is used for payment of services of a higher class, and wages confined to the earnings of labourers and artisans. That, I think, gives the broad notion of the generally prevailing meaning. He refers to the New Zealand or the Australasian Judicial Dictionary citing a New Zealand case in which it was said the term salary is ordinarily used to signify the periodical remuneration paid to professional men or persons whose duty it is to superintend, and who have in every case an appointment of some permanency. It is never ordinarily used as signifying the remuneration of manual labour or of any labour when the element of permanency is absent. So, my lady, my lords, that is what salaries meant in 1870. And for as far back before 1870, as the jurisprudence records, periodic payments of such salaries were always treated at common law as indivisible. They were treated so in 1870, and they've been continued to be treated in that way in every case to date. They were treated so in the earlier years of the last century, despite the respondent's submission to the contrary. Can I just give you a reference to save time? The respondent relies in its printed case on the case of Healy. That's at tab 5 of the core bundle. That was a case where an annual salary was paid monthly in arrears to a managing director who claimed unpaid salary for the months of June to October, the court finding that his contract terminated on the 22nd of October. The court found he was in principle entitled to his salary, but gave him his salary only for June, July, August, and September, but not for October because he hadn't completed that month. So, in fact, Healy is authority for the proposition completely opposite to that for which it's cited by my learned friends. I only say so because I want to establish that as I say, every single case has treated salaries in the same way. They were, of course, treated in the 1980s in the same way in SIM, and perhaps more relevantly for present purposes, they were treated in two recent reasoned judgments of the Court of Appeal in that way, both in Fasihi and in this case. And can I just take the court within the core bundle to page 153, just to see how Lord Justice Elias deals with it at paragraphs 30 to 32. This goes to the respondent's new case, so forgive me, it's slightly out of order, but starting at paragraph 30, uncertainties, this is page 152, forgive me, uncertainties about the scope of the Act have now been resolved in Fasihi. That case concerned an alleged breach of fiduciary duty by an employee who was also a director. He received a salary paid monthly in arrears. His contract was terminated on 26th of June for misconduct, and one of the issues before the court was whether he was entitled to his salary for the period in June for which he worked. Paragraph 31, Court of Appeal disagreed with the first instance judge. It accepted at common law the employee could not recover anything because his salary did not accrue until the end of the month. But the court considered that the Apportionment Act did apply, and that on that point, the famous Boston deep-sea fishing case was per incuriam. Accordingly, since salary accrued day by day, the employee was entitled to a salary until his dismissal, even where it was for misconduct. The court expressly rejected the view expressed by Paul Matthews, the writer of an article, as to the limited application of the Act. And Mr. Justice Holman, with whose judgment Lady Justice Arden expressly agreed, said...
Is that now Master Matthews?
I don't know, my lady, I'm sorry. I just don't know. Said that since the Act is a remedial Act and since the common law rule works in injustice, the Act should not be restrictively interpreted. This would suggest that it will now be readily applied to all employment contracts where the common law principles pertaining to entire contracts and substantial performance would operate. It follows that the Act does in principle apply to the contracts of these teachers, the appellants. Their pay is deemed to accrue daily. That was also the view of Mr. Justice Scott in Sim, although the point was not directly argued. None of the parties had at that stage sought to contend otherwise.
Can you just help me about that last sentence? Paragraph 32 follows the Act does apply. Pay is deemed to accrue daily. None of the parties have sought to contend otherwise. So one noted that, then one worked one's way through this judgment, and one came to paragraph 56.
My Lord is following a thought
Ms.
process.
McNeill, counsel for the college, submits the Apportionment Act simply has no application. Now, why did I fail to understand how those two sentences fit together?
My Lord, it's not that easy. The argument, and it was a nuanced argument that found little favour and is not now pursued, but the argument was that although the Act applied to the contracts, it didn't apply in respect of working out the deduction for the day of strike. That is, that's how I understood the argument, and that's certainly what I understood that reference to be. But if I've got it wrong, I'm afraid my learned friend Mr. Cooper is probably the best person to ask. It was part of the...
Perhaps 56, first sentence, is a little bit too wide.
I think, my Lord, it is, but...
Ms. McNeill wasn't making a submission quite so broad.
I didn't believe so, no, my Lord.
Thank you.
But I did find that part of the case not translucent.
No.
In any event, that is why, in 1870, salaries were expressly included as a type of annuity, along with other periodical payments of income, as needing to be treated as accruing day to day. My lady, my lords, there's been little debate in the courts on the construction of Section 2 between 1870 and the Court of Appeal's judgment in this case, save that the words from day to day have always, I stress, been construed to mean, in respect of annuities, salaries, etc., equally every calendar day, as opposed to each working day. And that issue has actually come up. It's been dismissed by the courts, but that issue has come up. And that's true both in employment cases and non-employment cases. Can I just give the court the references to the 3 recent employment cases where that question of what from day to day had to mean in Section 2 was considered? The first is the case of BCCI in the additional authorities at tab 11, volume 1, reference paragraphs 52 to 58. The second is...
Oh, could you give me a page reference?
Yes, but it'll take me a moment. 1060. I'm very grateful.
1060.
The case of Reynolds in the second bundle of the... I wasn't suggesting that we read them, though obviously I'm entirely comfortable that we should. It just will take 10 minutes or so, this little exegesis. So all I wanted...
1060, did you say?
Paragraphs 52 to 58 in the judgment of Mr. Justice Evans Loam.
So that's non-core, volume 1,
Correct.
tab 11.
Correct. And then the next...
Could so describe them. That would be very helpful.
I will do so, my lord. The next is non-core volume 2, tab... sorry, forgive me. 31, page, well, the case is a short one. It starts on, well, it's actually one of these cases where the original printing of your non-core authorities bundle was defective, and therefore this particular case probably doesn't have an MS number, as it were, but it is, I hope, provided them to the court. We can do so again now. In any event, it belongs at tab 31, and the relevant paragraph is paragraph 22. And finally, the case of...
Sorry, I got a bit muddled there. There is a case in tab 31.
Does it say Thames Water Utilities,
Thames Water Utilities.
and Reynolds?
Yes.
And is it a proper report? Because
No.
That's what I thought.
But you sent it to us, or somebody did, and it did arrive electronically, but not hard copy.
You now have both. As I say, I don't invite you to read it now, but for reference, it's paragraph 22 within the judgment of His Honour Judge Clark. And the last case is the case of Amy, which is in your core authorities bundle at tab 2 in the judgment of Mr. Justice J at paragraph 23. And, my lady, the page number within the core bundle for that is 404. So those were 3 cases where the argument was raised, well, does Section 2 perhaps not mean calendar day in this context, but working day? In each case, the court said no. It's right then at this time for me to correct a mistake in paragraph 47 of the Court of Appeals judgment. A mistake has been adopted by the respondent. That's at page 156 of the core bundle. Where about 8 lines from the bottom, in a sentence beginning towards the beginning of the line, Mr. Justice J held that insofar as these cases seek to give a different meaning to Section 2 because of current employment practice, they could not be supported. I would respectfully agree the section cannot change its meaning as a consequence of changes in industrial practice, not least because it is concerned, for the most part, with periodic payments which are wholly removed from the employment field. What Lord Justice Elias is there referring to, the 2 cases just above in that paragraph, where he says this. He, that's Mr. Justice J, noted that 2 more recent authorities from the Employment Appeal Tribunal, McConaughey and Yarrow, had concluded that these cases should not be followed, the 3 I've just taken you to, because they were out of touch with industrial relations practice, as reflected, for example, in the working time regulations. Those cases, and this is the mistake, those cases held that the reference in Section 2 to accruing from day to day must mean the working day. The cases, in fact, say the opposite. What they say is that Section 2 of the Apportionment Act does require the calculation of untaken holiday pay, which was the issue in those cases, to be by reference to calendar days, but that later legislation, the working time regulations, which came into force in 1998, requires that that particular calculation of untaken holiday pay should be by reference to working days and not in accordance with Section 2 of the Apportionment Act. And those cases are at tabs 20 and 34, respectively, of Volume 2 of the Additional Authorities Bundles. It's a small point because, as my lady, my lord see, the Court of Appeal declined to follow the conclusion it wrongly recalled those cases as reaching, but it does confirm the point I make, that in employment cases, just as in non-employment cases, 150 odd years of jurisprudence until this Court of Appeal judgment has been consistent in construing Section 2 as requiring an annuity, including a salary, that is paid periodically to accrue at the rate of 1/365 each calendar day. And it's, of course, a trite presumption of statutory construction that day or days in a statute means calendar days unless the contrary is stated. And I stress, even in contexts where the material event that the statute is describing cannot occur, for instance, on a Sunday. And in that regard, it is worth, I say, looking at one last authority in this context, and that's Anderton in the Additional Authorities, Volume 1, at tab 9, page 1016. That was a case in which the Court of Appeal had to consider the rules in relation to the deemed date of service of a document posted by first-class post. If one goes to page 1027, one sees the issue.
I thought I remembered this case.
Yes, indeed. So this is within the judgment of Lord Justice Mummery. Paragraph 9, deemed service. Rule 6.7 tabulates the method of calculating the day of service, and in the right-hand column there is the deemed day of service. And in paragraph 10, in the case of first-class post, the deemed day of service is the second day after it was posted. And the argument was, well, if you post something on a Friday, you can't get there on a Saturday or a Sunday, so the second day ought to be Tuesday. And the court had to consider that argument and construe what day and deemed day meant. And if we go to paragraph 37 on page 1034, are Saturday and Sunday excluded from the calculation of the day of deemed service? In our judgment, they are not. 38, it's submitted on behalf of the defendants that the later amendment of the rules must have been intended to clarify or highlight the existing effect of Rule 2.8, etc. The intention must have been that Saturdays and Sundays should be excluded. We go to paragraph 43. This court has had the benefit of fuller argument on that point than in this previous case, and we conclude that on the natural and ordinary meaning of the language, Saturday and Sunday are not excluded from the calculation of the day of deemed service by first-class post. And then the real reason for taking the court to this judgment is, if one goes to the next page, 1036, within paragraph 44, just above C, as it is, the word day, not the defined expression business day, is used in the part of the table dealing with service by first-class post. Saturday is a day, so is Sunday. The fact that there is or may be no postal delivery to the defendant or to his legal advisor on either of those days, or that there may be no one at the premises to deal with documents that are delivered on those days, is legally irrelevant to the operation of the fiction of deemed service. The deemed consequences inexorably follow from the method of service selected by the claimant. They are not dependent on the particular circumstances of the defendant. We are aware that this construction appears to produce a surprising mismatch of the different times of deemed service of a claim form. And then they set out why. He sets out why. Picking up the 4 lines below, it is a matter for consideration whether the rule should be amended. Surprising results are not uncommon, however, when a court obediently observes a legislative direction to leave behind the facts of the real world and to move into a fictional legal world as deemed to exist by enactment. Now, that's a very strongly worded statement, but as my lady no doubt caught, this is a proposition that the respondent appears entirely to reject. My lady, my lords, the proper construction of Section 7 of the Act has attracted more judicial attention. Can I take the court to three cases
The
very quickly?
Apportionment Act doesn't deem, does it? It considers. I mean,
My lord,
is it really any help at all, the CPR?
I would respectfully suggest that in the context in which we're speaking, that is a distinction without a substantive difference.
I see. Righto.
And it has been common ground between the parties, and indeed was so stated expressly in the Fasihi case, that this is, I use the words of, I think, Lady Justice Arden, a deeming provision.
Right.
Section 2. And certainly in the judgment of Mr. Justice Holman as well. So the cases I was going to take the court to in relation to Section 7 start at tab 16 within the core bundle of authorities. Aha, which I momentarily managed to lose but have now retrieved. That is the case of Tyrrell and Clark. My lady, it begins at 661 of the electronic bundle. And this, in fact, was on the same predecessor provision. The case antedates the 1870 Act. And if I can take the court to 663, at the beginning of the judgment of the Vice-Chancellor, 92, paragraph 92. The decision of this question of apportionment depends on the construction of the language of the statute. Before the statute, if there was a gift of the dividends of stock for life with a remainder over, if a question arose whether there should be apportionment, whatever were the terms, no apportionment was ever made unless the testator expressly directed it. In other words, that would, before the Act, have taken effect under any will which is in the words directed in this will. But the Act says that there shall always be apportionment, except in the case accepted by the third clause of the Act. That's our Section 7. The question is, what is the meaning of expressly stipulating? It is insisted that it means where you can infer from the whole context of the will that the testator did not intend apportionment. I think the statute does not mean that. It means that there must be in express terms that which amounts to a stipulation that no apportionment shall take place. Then it was also urged by Mr. Hall that even if the construction of the statute was different, there is here no sufficient indication of intention. Now, without going into that, it appears to me that if the legislature had meant that this court should, on the construction of a will, come to a conclusion whether the testator had used terms which on the whole indicate an intention to exclude apportionment, the clause of exception, Section 7, would have been very differently worded. The legislature has required an express stipulation. It appears to me that that language requires something very different from inference to be collected from the general terms of the will. No doubt there may be cases where, though the testator has not inserted in so many words a stipulation that apportionment shall not take place, yet he has used terms of gift so clear, so express, as necessarily to exclude apportionment. That would amount to an express stipulation. But that is a very different from saying where a testator has, instead of an express stipulation, used language such as is found in this will, the court is to infer that he intended to exclude the operation of the statute. Well, that case was cited and applied by the Court of Appeal in a case called Lysett and Lysett. That's at tab 9 in the same bundle. Electronic page 493. By the Master of the Rolls at page 497. Excuse me. Just a few lines from the bottom of the page, about, I would say, 10 or 11. There's a sentence beginning, "That is, in my opinion, a stipulation within the meaning of Section 7 of the Apportionment Act, that no apportionment shall take place." The word stipulation is a very bad one to use in the Apportionment Act, but having regard to the interpretation put upon similar language in a similar act by the Vice-Chancellor and Tyrrell, this clause is plain enough. There is to be no apportionment between the legatees of these shares and those who take the residue. That get rid of the Act entirely. The last of the three cases is at tab 6 of the same bundle in Rejoel's Will Trusts, electronic page number 420. That is important in particular because it's the first one that uses the precise formulation necessary implication that found favour with Mr. Justice Jay and to some extent with Lord Justice Elias, although Lord Justice Elias, as you will recall, thought that it was impossible properly to construe Section 7 in the way that the respondents had argued, but that nonetheless it had to be as a default if he was wrong about his construction of Section 2. So necessary implication features in this case. At 429, at 23 internally between D and E, Mr. Justice Gough, as he then was, says this. The first question which is raised on the summons is whether the Apportionment Act applies, and in my judgment it does, for the following reasons. The first of those reasons is that the words of the Act are general and unqualified, and the cases show that the Act is only to be excluded by express words or necessary implication, not by any general inference. They cite the words of the section, they cite Tyrrell and Clark and Lycett and Lycett, and say at the top of the next page that in effect that section meant what it said. The Act could only be excluded by words expressly so stating or requiring that conclusion by necessary implication. So necessary implication is used there quite expressly to mean exactly what those previous two cases have said, and not, as I respectfully suggest, is implicit in the more recent cases of Amy and the Court of Appeal judgment, in this case something very different indeed. So, Section 7 only applies where the terms of the document necessarily preclude the application of the Act because some other basis of payment inconsistent with any apportionment over time is clearly provided for. And one might almost say it's common ground, but certainly there is nothing in the appellant's contracts meeting that requirement for the derogation from the general position set out in Section 2. On the contrary, leaving aside the increasingly detailed analyses deployed in this case by the respondent, one might stand back and recall what Mr. Justice Mackay referred to as the obvious arguments which would arise as to how payment for a teacher's duties might be fairly apportioned, or perhaps the assessment by Mr. Justice Scott that interpreting the teacher's pay as accruing under the contract only during scheduled school hours is fallacious. So why are we here? The problem can be traced back, in a sense, to the famous case of Miles and Wakefield in your core bundle of authorities at tab 11, and to the speech of Lord Templeman. My lords, the speeches do not refer in terms to the Apportionment Act. However, the successful employer had submitted, one sees that from the reported argument, that Section 2 did apply to the plaintiff's salary.
We could do with a reference.
It's at page 5. Initially I'll give you the internal page number. The electronic bundle number is, forgive me,
513.
543 internally, so it is
Tab 11, page MS 530.
534 of the electronic bundle. So very, very bottom line, this is within the argument of, as he was then, Alexander Irving QC. The Apportionment Act applies to all salaries and employment. One sees the same thing 2 pages later, electronic bundle 536, just above H. The plaintiff's salary is an annuity, as defined in Section 5, and by the provisions of Section 2, accrues from day to day and is apportioned in respect of time. Those are the only references in the reported case expressly to the Apportionment Act. And Section 7, I note, wasn't even referred to in argument. The only part of the speeches of their lordships which deal with the potential bases of apportionment is within Lord Templeman's speech, page 547, electronic bundle, bottom right, internally at 55, forgive me, sorry, 556 at F. It's not a passage, strangely, that my learned friends cite from this case. They cite other passages. This is, as I say, the only place where the different potential bases of apportioning salary is dealt with. And what Lord Templeman says in these famous words is this: if an ambassador and the embassy porter were both on the strike, I would expect both to be liable to lose or both to be entitled to claim their apportioned remuneration. attributable to the period of strike. A judge and an usher on strike should arguably be treated in the same manner. The ambassador might be required to decode a declaration of war on a Sunday. A judge might devote his Christmas holidays to the elucidation of legal problems arising from industrial action. One can imagine the wry smile that accompanied the writing of those words. This was a case of industrial action dealt with in that period. So that it would be necessary to divide their annual note salaries by 365 to define a daily rate applicable, whereas the weekly, daily or hourly note wages of the porter or usher provide a different basis for apportionment. But it's, in principle, difficult to see why there should be any difference in treatment. To decide this appeal, it suffices that there's no logical distinction between a registrar who's paid a weekly salary for a 37-hour week and a municipal dustman who's paid a weekly wage for a 37-hour week. If both are on strike, both are supported by their unions, and both claim from the council payment in full of their salary and wages for the duration, middle-class morality must not be allowed to place Mr. Doolittle in an inferior position in this respect. Now, the reason that becomes important for present purposes, although we say that it's very unlikely Lord Templeman did have Section 7 of the Apportionment Act in mind, as we say, it hadn't been referred to even in argument, and it's very difficult to construe Section 7 as having that effect, as Justice Elias has pointed out. However, a later case, Cooper, did interpret Lord Templeman in that passage as assuming that Section 7 of the Act would disapply Section 2 in respect of employees who have a very strict, fixed working pattern. That case is at tab 3 of your bundle. So in Cooper, the claimants were support staff employed to work a fixed 37-hour week Monday to Friday, and work outside those times was paid separately or taken as time in lieu. And following a one-day strike, the High Court determined that the appropriate calculation of the lawful deduction was 1/260 of the annual salary, including Mondays to Fridays throughout the year, paid holidays in that case being taken into account. The important paragraphs are these, starting at the electronic page number 508, paragraph 6. 408, sorry, did I say differently? I apologise. 408, at paragraph 6, Mr. Justice Blake, under the heading Contracts of Employment, says that he's going to state 4 facts which can be deduced. And within B, the second fact, about 5 lines down, he says this: "At first, I was troubled whether there was not a basis for saying that the daily wage of the support staff is to be calculated as 1/0.65, as the Employment Appeal Tribunal appears to have concluded in Taylor, relying on the Apportionment Act, Section 2. I note, however, that Section 7 provides that the application of Section 2 is subject to any scheme in the contract, and in Taylor there were no countervailing provisions in the contract for apportionment. I further note that the judge was troubled by the absence of a respondent to the appeal. For present purposes, I'm satisfied that where there is a definition of a normal working week in the contract and a contractual entitlement to holiday pay, then the salary payable, whether expressed annually or otherwise, or whenever paid, should be apportioned over the days of the normal working week." Now, that is the bare statement, as it were. Paragraph 16 explains why. Lord Templeman's analogy with the liability deductions of the ambassador or judge who went on strike provide direct support for Mr. White's submissions, recognising that judges and ambassadors do not work a defined working week of 37 hours, and that the performance of their duties may require them to work over weekends and public holidays. The performance of their duties may require them to work over weekends and public holidays. He would divide, there's a typographical error here, but the sense of it is clear, 365 by 1, to find the deductible proportion for a day's withholding of labour. This is the only place in the judgment that one of their lordships moved from general principles to any indication of how the deduction is to be calculated for an employee paid on an annual salary with no defined hours of work. The position of a person employed on a contract with a defined working week of 37 hours is not the same, and Mr. White does not contend that the deduction in the present case should be 1 over 365. However, although judges can be required to provide services on any day of the year, they are not required to provide services on every day of the year. I just pause there. It's such an obvious point, but one might need to bear it in mind when one reads or hears some of the respondents' submissions in this case. They are entitled to holidays. They will be entitled to time off in lieu for weekend and bank holiday service once an initial period of so-called statutory leave has been worked off. Lord Templeman would only deduct for the day not earned and not a proportion of the holiday period that the judge would be entitled to take. The court held, therefore, that Section 2 did not apply, in that case, only and expressly on the basis that the claimant's contract in providing for a working week limited to a regular 37 hours satisfied Section 7. We don't accept, respectfully, that Section 7 does apply in such cases, but for present purposes, the point is that the court held that Section 2 would have applied absent those strictly defined hours of work. And that, my lady, my lords, is how matters stood when these claims were intimated. And in pre-action correspondence, the respondent relied on Cooper and said, you appellant teachers, are in the same category as the support staff, not as the judges. Section 7 applies, and therefore your claims will fail. We disagreed, the claims were issued, but before they were heard, a similar case came before the court as a Part 8 claim in Amy, in which a different college's argument, based on Cooper, succeeded. That's at tab 2 in your core authorities bundle, electronic 401. And we say, and I'll obviously take the court to parts of this judgment, but we say there are 3 fundamental flaws in the analysis in Amy. The first is a factual one, because the court either misunderstood or it wasn't properly explained to it. As I say, it was a Part 8 claim, there was no oral evidence, that Mr. Amy's teaching duties, what Mr. Justice Jay refers to later in the judgment as his pedagogic duties, the court didn't realise that they are defined in Appendix 4 incorporated into his contract. Indeed, the court appears not to have been referred to Appendix 4, certainly from its judgment.
Sorry, didn't realise that his teaching duties were what?
Were defined in that appendix that sets
It's
out...
the same appendix, is it?
Yes, absolutely. It's the same contract.
Yeah.
Mr. Amy, that's... Yes, it is the same contract.
The facts of Amy are really on all, apart from striking, I think, for 2 days or something, the facts are on all 4.
They are, which is why the Court of Appeal gave us permission to leapfrog, because we had to accept, Amy having been decided, that we couldn't contest in the county court the claims, but we needed to go one step further, as it turns out, 2 steps further. So Appendix 4 is not referred to in the judgment, and as a result, the court was persuaded to reach the quite erroneous conclusion that the work Mr. Amy did during directed time was pedagogic, and the work he did during undirected time was ancillary, precisely the fallacious division as to function that was, I respectfully regret to say, adopted by the Court of Appeal in this case.
That if that was an error, wasn't it as much visible in the contract itself? And did one need to look at Appendix 4 to see that that was an error, if such it was?
Well, my lord, I would suggest not, but it's the difference between identifying an error trivially and identifying it with some spade work. If you've got Appendix 4 in front of you, it's trivial. Without Appendix 4, the conclusion should have been the same, but it requires a little more analysis. But we now agree, everybody now agrees, not just the court and myself, but also my learned friends, that the duties performed in directed time and undirected time massively overlap. That is precisely the contrary position to that adopted at paragraph 39 of this judgment. So that's the first flaw. The second flaw is not at all to be laid at the door of the judge. The second flaw is that in construing Section 7, which the judge described as not an easy provision to construe at paragraph 23, the court was not referred to any of the authorities on its construction, and thus departed per incuriam from the law as set out in Tyrrell, Lycett, and Joel Will's trusts. But those are almost just the backdrop to the most puzzling flaw in the judgment.
But I'm sorry, you haven't really explained your point 2. In what way did he depart from the traditional jurisprudence on Section 7?
He effectively found, my Lord is absolutely right to take me up on that. He found that if you go to paragraph 23 initially, I've not found Section 7 an easy provision. Plainly, Section 2 is of no application where legislative or contractual provisions expressly preclude apportionment on a day-to-day basis. The draftsman has, after all, used the word stipulated. And then point 2 sort of merges with my point 3, because the reason he did was because he, we say, misunderstood Cooper. Yet in Cooper, Mr. Justice Blake went slightly further. He held at paragraph 6b, which I took you to, that Section 2 was disapplied by Section 7 in a case where the relevant contract of employment provided for normal working week, which excluded weekends. And I'll go back to the analysis of Cooper in a moment, but the court found, therefore, that it could be implied, necessarily implied, that the contract of Mr. Amy was precluding apportionment on a calendar day basis. But in finding that it so necessarily implied, it was per incuriam of what the courts had said necessary implication needed to be. I can't prove a negative because he doesn't deal with it, but needing to be that there is something in the contract which is express and inconsistent with the apportionment as provided for in Section 2 applying, not that one could infer from the will or the contract that that might not have been the intention of the parties.
I mean, whether we have to grapple with this in the end, I'm not sure, but Section 7, I understand what you say about Tyrrell and Joel, of course I do, but can you ever infer something or imply something into a contract unless it is necessary?
Well, that's a very pertinent question in the light of recent jurisprudence. But, my Lord, there are, as we know, tests. That's one of them, and it's argued about exactly what is required in that situation. But in this context, the cases, and it's my fault or the lack of time, I suppose, I didn't take you to the facts of those cases. But if you have a term in a will, let's say, that says, on my death, the benefit of this part of my estate should go to so-and-so, but the benefit of the same part of the estate should, on my death, afterwards go to someone else, that is a term that you cannot construe in accordance with Section 2. Because if the payment in respect of that part of the estate, let's say it's a dividend, is paid 3 months after he dies, then if the Apportionment Act were to apply, that would accrue day by day, whereas the testator has made a specifically different provision, or he may say, as in one of the cases, that only one person should get the entire benefit of that dividend. So if there's a term in the will, in the contract, which just effectively says, even though it doesn't use the words apportionment or Apportionment Act, that the apportionment of this payment does not apply, does not accrue daily, even if it doesn't use the words apportionment or accrue, then there's a necessary implication, but only then. But
Mr. Siegel, are you saying that if at the end of this we go away and think about it carefully and come to the conclusion that Mr. Siegel's arguments, based on the contract for 260th, for 365, and Mr. Linden's arguments on the contract for 260 are different, but actually of totally equal potency, then you win?
Well, I'm saying
are you saying
more
that?
than that? I'm saying a lot more than that, but yes, I am saying that. I'm saying that unless Mr. Linden's arguments persuade you that there are express terms of the contract which are inconsistent with my argument. In other words, he has to not simply show put a good sort of face on it, put his best foot forward. He has to actually vanquish the alternative entirely. Then, yes, necessary implication. If there is a term in this contract, I mean, there isn't, but if there were to have been a term in this contract that you could look at and say, that means apportionment cannot apply, then yes. I mean, the best evidence that there is no such term, one might say, is that Lord Justice Elias couldn't identify one, but identify a candidate, as it were, for that sort of inconsistency. Instead, both Mr. Justice Jay and Lord Justice Elias, insofar as Lord Justice Elias was prepared to countenance Section 7 applying at all, looked for a different sort of implication. What can we infer from this clause and this clause and this clause, set aside this clause, and precisely the sort of exercise my Lord was envisaging. If we balance them all up, then we see that maybe the inference as a whole is X, not Y. That is precisely the exercise that those three cases, Lycett, etc., said it was impermissible to conduct. But, my lords, as it were, we're skirting around the edges in respect of Amy, because those are the backdrop to the most puzzling flaw in the analysis. Because the analysis basically says, I follow Mr. Justice Blake in Cooper. And
Mr. Siegel, just before you get on to that, is there not a fairly straightforward pathway through this, in this sense that Section 7 can be seen to apply where the parties agree to exclude the whole idea of apportionment altogether? And if you say that in this particular contract it does not have that effect, then the question really is, does day-to-day accrual have one single meaning, or does the interpretation of day-to-day accrual depend on whether the contract is one that limits the employment to a certain number of hours or days of the week, or on the other hand is a contract where potentially the employee may find himself working over 7 days?
well, my lord,
Is that not the simple way through?
it is a simple way through it, and obviously if one followed that particular path, I would be very happy. But I suppose I have to take on board that although Lord Justice Elias agrees with you that that's the natural construction of Section 7, that isn't the construction that Mr. Justice Blake or Mr. Justice Jay put on Section 7. And I also have to take on board that my learned friends say that this contract, as Mr. Justice Jay found Mr. Cooper's contract, is in fact exactly the same for material purposes as the support worker who works a strict 37-hour week with overtime. And that's the point I was about to come to.
Well, that's the point, isn't it? Well, at least one would have thought so.
Well, that was where...
You don't need to overcome Cooper on the proposition, do you, for the present purposes, on the proposition that if you're employed on a weekly contract, effectively hour by hour, the process of apportionment is different from the person who's employed on an annual salary payable monthly.
My Lord has articulated very concisely and accurately precisely what we believed the issue in this case to be, but we turned out to be wrong.
Yeah, okay.
So as I say, that was what everybody thought at one time the issue was. Was the analysis of the 37-hour support workers contract apposite for these appellants' contracts, or were they more akin to the judge's contract? And what Mr. Justice Jay says is the former. But we don't understand why, save that, and he must have read this, one assumes, he doesn't cite or refer to the critical paragraph in the judgment of Mr. Justice Blake, which says the opposite, which is paragraph 16. So we say with respect that Mr. Justice Jay's analysis of Mr. Amy's contract must be wrong. Even putting aside the issue of whether he got the factual context right and about the failure to consider the cases of Lycett, etc., putting more long-windedly, I suppose, what my Lord has just put to me, if the test was whether Mr. Amy or the appellants should be treated as akin to judges who, as well as sitting in court at scheduled times to hear cases and deliver judgments, I quote, may also be required to work in the evenings and weekends properly to perform their professional role, or akin to the support staff working the 37-hour week who can't be required to work a single extra hour without extra pay or time off. It seemed to us plain into which category they fall. So it's perhaps embarrassing to record that we approached the Court of Appeal hearing in this case very optimistically. And our optimism seems to be very well founded at the hearing. The respondent expressly conceded that the Act applied in principle to the contract, and that from day to day meant in the context of an annuity, an annualised salary, equally each calendar day. And no one suggested an alternative construction. As I say, they ran this argument, which I won't try to rehearse, but basically they ran the Section 7 Amy argument that these were like support workers, not judges. And that argument in particular in the Court of Appeal seemed to find little favour because it was pointed out by, in fact, more than one of their lordships, that it was not easy to identify the necessary express stipulation that Section 2 apportionment should not apply. This is on the basis that this is on the non-simple route. My Lord will identify. But this is if you assume that Section 7 is apposite to opt for a different type of apportionment as opposed to no apportionment. But nonetheless, the court pointed out that it's difficult, even in that context, to identify the necessary express stipulation that a different sort of apportionment should apply, when no one was able to identify even an implicit contractual stipulation as to what the alternative apportionment should be. In fact, as we sit here today, my learned friend's printed case says the Court of Appeal has come up with this. In fact, they were too generous. The judgment, therefore, weeks later, was something of a shock. And it placed a new construction on from day to day via this intermediate step of presuming and then undermining something it referred to as the principle of equal daily accrual, meaning accrual at the same rate of income every day, regardless of whether the contract or other document provided for that rate to increase, or decrease, I suppose, during the period of the contract. And the basis of that reasoning, as one sees in clear terms from the judgment, is entirely that the natural and well-established construction of the Act might lead to unfairness. Can I take, my lady and my lords, to that judgment now in a little more detail? Within the core bundle begins electronic page number 148. And one sees at paragraph 34 on page 153 just skimming through the first part about, no doubt for most periodic payments it will be a 1/365. If I can pick it up 6 lines from the bottom.
Of page?
Oh, sorry, page 153, para 34.
Thank you.
A line and a sentence beginning moreover. Moreover, to construe Section 2 as having that effect would create a new source of unfairness, where the rigid application of a daily rate of 1/365 would create an injustice in the context of the particular arrangement between the relevant parties, which is difficult to suppose Parliament intended. And the present case illustrates the sort of problem which could arise, note not which does arise, if the College's argument about the unfairness and inappropriateness of deductions being made at a rigid daily rate are accepted. And then again at paragraph 37, 4 lines down towards the end of the line. However, if there is a principle of equal daily accrual, and especially if the parties cannot contract out of it, that would lead to curious and potentially unjust consequences. And then they turn to the first, as it were, hard facts case, which I'll turn to in a moment. But first I say this, that the premise, the unfairness that the Act as it's been construed all these years, might give rise to, we say is, with respect, deeply flawed. But also the conclusion based on it, even if the premise were sound, namely that a novel construction of the Act must be adopted, is a complete non sequitur, as we saw from the Anderson case, as we will see in particular in the Marks and Spencer's case, a recent decision of this court decided after the Court of Appeal case, where, again, a party asked for a section of the Apportionment Act to be construed in a way contrary to the way it had been construed these many long years. And in that case, as we'll see, the Supreme Court said, well, actually, the argument that you raise is not a bad one. It's not obvious what the construction should be, but nonetheless, it's well settled, and there's no need to avoid inconsistency or repugnance, etc., to adopt your new construction, even though that would lead to a much fairer result. So we won't. So both premise and conclusion, but first premise. The principle of equal daily accrual as defined by the Court of Appeal and presumed to be implicit in Section 2 was not, and I cannot stress this enough, was not a construction that either party had advanced as correct. So we never had the opportunity to say, well, what you're suggesting is potentially going to lead to unfairness isn't something we suggest should happen.
I'm sorry, can you specify a construction
Absolutely, my Lord.
that was not contended for but has been adopted here?
Yeah, my Lord, absolutely. So I do so with this introductory sentence to make clear the answer that I'm about to give. In the case of unvarying, annualised, periodic payments, annuities, annual salaries, such as these, of course, Section 2 does have the effect, and always has had the effect, of deeming accrual at the rate of 1/365 every day, because they are unvarying, annualised payments, and only for that reason. And that's why, of course, Parliament included these as an annuity when they incorporated salaries into the ambit of the Apportionment Act. But we did not suggest, and this is to directly answer my Lord's question, that in respect of other types of income, one entitlement to payment should be aggregated with another entitlement to payment, such that the total over a calendar year should be added up and divided so that they accrue at 1/365. And if you're looking puzzled, bluntly, it's easy to see why. However, the answer to that puzzlement will be found at the remaining part of paragraph 37, where Lord Justice Elias brings into play this first hard facts case. The implausible scenario envisaged is a lease for 12 months with a lower rate applying for the first 6 and a higher rate for the next 6, but with a single aggregate payment due at the end of the year. I mean, it's implausible on so many levels, but the point was this. The Court of Appeal considered that the settled application of Section 2 would work unfairly if the landlord changed after 6 months, because it assumed that under the Act, the rent would be accruing in equal amounts throughout the 365 days of the year. However, indeed, Section 2 requires no such result. Rather, pursuant to Section 2, the rent accrues from day to day at one equal daily rate for the first 6 months, and from day to day at another equal daily rate for the next 6 months. So even this implausible hard facts case isn't actually a hard facts case at all. And we say a related misanalysis undermines the Court of Appeal's reliance on Section 5 of the Act as providing support for the new construction of Section 2. We see that at paragraph 35, back a page. The two features of the Act support this analysis. The first is that in Section 5 there is a definition of dividend by reference to various forms of payment, including payments out of the revenue of trading or other public companies, etc. And the provision then goes on to provide expressly that all such divisible revenue shall, for the purposes of this Act, be deemed to have accrued by equal daily increment during and within the period for or in respect of which the payment of the same revenue shall be declared or expressed to be made. And it's a sort of expressio unius point. If Section 2 automatically envisaged that payments caught by the Act would be deemed to accrue by equal daily increments, these words would not have been required. But we say that the only reason it seems obvious for the inclusion of the phrase by equal daily increment in the definition of dividends is because, unlike annuities, which are necessarily paid on an annualised basis, dividends and bonuses can be paid in respect of any period. And Parliament was simply making it clear that where a dividend is paid for any period, including a period other than a calendar year, then the daily accrual deemed by Section 2 is deemed to happen pro rata or equally in respect of each day of that period. Now, that is, of course, all consistent with our case, but would, if the Court of Appeal's construction of Section 2 is right, create a truly anomalous position that whereas a dividend must be deemed to accrue daily each calendar day, equal amounts, an annuity, which one would have thought was the paradigm of such a payment, may be deemed not so to accrue.
So, Mr. Siegel, I'm sorry. I need to get this clear in my own mind. You said almost at the outset of your submissions, Section 2, day by day, refers to calendar days.
Yes.
And you showed us authorities to that effect. The complaint you make about the Court of Appeal is they've crossed out the word calendar. Is that right?
No, I think if I were, my learned friend will do it much more eloquently than I, but if I was speaking for Lord Justice Elias, I think what he would say was, I'm not crossing out calendar, I'm just saying that on a Saturday and a Sunday, the accrual is nil, and then on a Monday, it's 1/260. I think...
Well, that is crossing out the word calendar.
Well,
the calendar has Saturdays and Sundays.
My Lord, I'm trying not to, as it were, treat my Lord's question in the way that I would want, which is to say, of course. But my Lord asked me, as it were, to
Yes. Well, that's very
try
proper
and
of you.
explicate what Lord Justice Elias would himself say or had said. And I think he would say no. I know that because he says that he doesn't follow the two cases which he thought wrongly had opted for a working day construction of from day to day in Section 2. He says, I don't follow that. Industrial practice changing can't change what from day to day means, but then goes on to reach the conclusion he does. I better not say any more about it than that.
But is your point about Section 5 that dividends may sometimes be allocated to a period other than a year?
Yeah, absolutely.
Well, of course that's right, but then Section 2 isn't limited to annual payments, is it?
No, it isn't. I mean, my Lord, it is, in a sense, an avoidance, for the avoidance of doubt
Yes, I see.
provision.
Yeah.
But the point I wanted to make, one that I don't believe Lord Justice Elias addresses, is if he's right, then we do have this very, very curious position. We have to assume that Parliament told people that if you're paying a dividend, it must accrue every single day equal amounts. But if you're paying an annuity, well, that's different. Then it can accrue in different amounts each day. And I ask rhetorically, because I know of no answer, what possible basis might Parliament have inferred to have wished to legislate to that effect? It's a point that was actually canvassed by one judge in one case. It's a judgment I've referred to before. I won't take my Lady my Lords to it, but it's Mr. Justice Evans Loam in the BCCI case, which is in non-core tab 11. It's that paragraph I already referred the court to, paragraph 54. So that precise point has, as it were, in passing, been considered by the courts, but it wasn't considered by the Court of Appeal in this case. And I simply ask rhetorically, what possible basis could Parliament have had for legislating Section 5 in the way that the Court of Appeal inferred it to have done? My Lords, we need to turn on to two more hard facts cases that Lord Justice Elias identifies. The next is at 58, paragraph 58, Electronic Bundle 158. And that's the teacher who strikes for 3 days in a week. That was actually a hard facts case put forward by my old friend Neil Queen's counsel. And what Lord Justice Elias says in that paragraph at the bottom of the page, bottom line of the page, is on the appellant's case, they would receive almost 70% of their salary while completing only 40% of the work. Mr. Siegel responds by saying that the application of a default rule will sometimes have arbitrary effects, but that is no reason not to apply it. My lords, that is to do very little justice to our actual submissions, though that was part of our general submission about the effect of deeming provisions, it is right. What we actually said was this, that in practice, the part of the syllabus missed during the lessons not taught will likely have to be taught and prepared and marked at other periods, and thus it's probably incorrect in practice to say the striking teacher will only be completing 40% of her work for the week in question. But if we're wrong about that, and depending on what the college does, we might be. So the college, for instance, could say, you've given us notice of this strike, we're going to ship in a cover teacher to cover those 3 days, and they'll have to do all the marking and all the prepping and teach all the lessons. So you really will avoid all of that work and its associated undirected time work. If that were the factual situation, then we said that the employer would be entitled to withhold the sum equivalent to 60% of the salary, either on the basis that that was the work not done, the 3 directed days plus all the associated work with them, or on the basis that the college has an entitlement to damages by way of equitable set-off in practice to cover the wage of the covering teacher. So it is a hypothetical case. No one suggested that the facts of it arose, but on either basis, it isn't actually a hard facts case. And as I say, our submissions are as I've stated them now, not as they're recorded there. The third...
So do you really need to concede that that would be an arbitrary effect? Should you not be saying there's nothing arbitrary about it at all, because it is only true that he would complete 40% of the work if you assume that nothing would be done on the Saturday and Sunday?
Well, I would respectfully not accept that, because, as will be more plain if we get to discuss the respondent's new case, the fundamental division between my learned friends and ourselves is that we say this contract is pay for work, not pay for days, just as bluntly everybody else's contract is. And therefore, what you are deducting for in any of these situations, whether by way of equitable set-off or by way of work not done, is the work not done. And if the teacher, let us say for the sake of argument, was due to teach full days, Monday, Tuesday and Wednesday, and let us say for the sake of argument was going to prepare those lessons on the Sunday and mark them on the following Saturday, just say for the sake of argument. And if the teacher did none of that, so didn't prepare the lessons, didn't deliver the lessons, didn't mark the lessons, then yes, of course, the college would be entitled to withhold the sum suggested. There's one last hard facts case that Lord Justice Elias presented to the parties almost on their way out of court, and therefore allowed them to make written submissions to deal with, which each party did. And that's set out at paragraph 62. It's his last of his potentially curious consequences. And that is where 2 part-time teachers share the same post, one a little implausible perhaps, but one teaching for the first 2 weeks of each month and the other teaching for the second 2 weeks, and they leave in the middle of the month. And the Court of Appeal say, again, on the claimant's case, they would each receive the same pay referable to that month. The value of their services would be deemed to be the same, yet the appellant would have provided, A would have provided work and B not. Now, again, that is bluntly contrary to what our actual submissions have been, and this time they're recorded in writing in your bundle, and if you want to look them up, they're at page 351. But what we said was this, that if the teachers were, as the hypothesis stipulates, not obliged to perform any work for their employer during the 2 weeks that they weren't at the college, then their salaries would only accrue during the periods of work. That's trite law. If there's no mutuality of obligation, as it's called, including the obligation to work, then there's no contract of employment subsisting. And during those other 2 weeks, of course, they could go and teach at another college. That would, on those facts, be a true example of a severable contract, where separate consideration is payable in respect of separate obligations to perform work. It would be what's described by Glanville Williams in the article in your bundle a periodic hiring akin to a periodic tenancy. I just give you the reference. It's at electronic 667 tab 17. And of course, the Act would not apply to that contract as a whole in that factual situation. But alternatively, if contrary to the stated hypothesis, the teachers were obliged to perform their lesson preparation and all their marking, etc., during the 2 weeks when they weren't actually teaching, so they were continuously employed by the one college, then, of course, the Act would apply and the consequences of the application of Section 2 would not be so curious. But fundamentally, of course, even with the analysis of these hypothetical hard facts cases correct, the supposed conclusion that the well-settled construction of Section 2 should be displaced to avoid such unfairness is unsound. And as I say, it's been specifically rejected in principle by a recent decision of this court. My lords, it happens not just in employment cases that one can dream up unfairly applied applications of the Act. An annual dividend, let's say, that accrues daily, even though the company's performance was dismal for 6 months, that the testator shareholder A owned the shares, but very successful in the next 6 months when the inheriting shareholder B owned the shares, or the annual rent of a holiday cottage in, well, never mind where, which accrues from day to day. It's payable monthly up to the point that a frustrating event brings the lease to an end, even if that happens just before the holiday period. Of course, it's unfair in a sense that the tenant has had to pay for this empty holiday cottage for 9 months of the year, and then it slips into the sea before he gets a chance to use it, and he's still liable. But so what, bluntly? And unless the Court of Appeal's construction is to be applied to all contracts where the benefit to one party is implicitly irregular, then some very anomalous results will arise. Take the appellants. If one of the appellants had a flat at the college, he lived a long way away, but Monday to Friday he stayed in this flat. He could have stayed there at the weekends, but he was never going to because his family don't live in the college. So the flat was intended in practice for his use Mondays to Fridays during term time. On the respondent's case, as I understand it, his salary would accrue on one basis, but his rent would accrue on another. But even more remarkable, we say, in the approach of the Court of Appeal in this case in constructing these hypothetical situations, is that it never addresses the actual situation, which is typical, the situation that applied in this case. When the teaching work, take Mr. Monk, so he's due to do a directed day, let's say. I don't know if it was a whole directed day, but let's say it was. So the class is cancelled. He has to do that teaching at some other time during the year. The syllabus is, you're not going to leave the syllabus incomplete. The associated planning and marking has to be fitted into the workload during the rest of the term. Now, I'm not saying he avoids no work, but in such a case, a deduction from the salary on the basis that he's avoided doing all the work, most of which he was still in fact required to do, is obviously inequitable. Whereas the application on the facts of this case of Section 2 gives an equitable result, as of course Mr. Justice Mackay noted in Smith. It's a reasonable compromise. And nor does the Court of Appeal explore the very curious results which would flow from its construction in other real-life situations, including industrial action situations. In the past, teachers have sometimes said, we will continue teaching our classes, but we will not invigilate. We will not go to staff meetings outside of school hours. We will not go to parents' evenings. We will not mark work outside of school hours. In other words, they won't do much or all of their directed time duties. Now, on our analysis, the respondent would be entitled to withhold part of the salary of such a teacher taking industrial action, albeit there would be mind-bogglingly difficult questions of quantum, perhaps. But on the respondent's analysis, they've earned all their salary. They've done their directed time. On the Court of Appeal's analysis, they performed their core duties and thus would remain to be entitled to their full salary. There is no need for a radically new construction of sections 2 and 5 to avoid what the case is referred to as defeating its object, the object of the Act, and creating a manifest absurdity. And as the Marks and Spencer's case, which I'll take the court to in a moment, and other cases confirm, there would have to be such a need before the court should abandon a construction which has been settled for over a century. So can I take the court now to tab 10 of the core authorities bundle, the Marks and Spencer's case, electronic page number 501, in which this court had to consider issues similar in principle to those raised in this case, and particularly, but not only, by the respondent's new argument. If I take up the report at page 517 electronically, this is within the judgment of the speech of the President.
No, we call them judgments in this court.
Judgments.
Report.
My lady, I'm
We're
great.
not making speeches in support of a motion before
That's
the
true.
House of Lords.
I should have realised. In that case, the claimant argued that a lease should, by implication from its terms, be construed to include provision in relation to apportionment over time, which ran contrary to the well-settled common law rule that periodical payments of rent are not apportionable over time, because otherwise the operation of the lease was, on the facts, as it argued at paragraph 33, just below B, unfairly prejudicial to the claimant and a pure windfall for the defendants. And just how unfairly prejudicial can be seen by the President's synopsis of the relevant facts at paragraph 35. I won't read it out, but if you'd be kind enough to read to yourselves 35 down to almost the bottom before the bracketed words, you'll see how unfair it all was. Now, that unfairness was in the end, when the President gave his conclusions, characterised by him as capricious and anomalous. That's paragraph 51, which I'll take the court to momentarily. But what is pertinent to the present case is that even in those circumstances, so even when you have such manifest unfairness on the actual facts, the court considered whether it could properly be argued in principle that the long-standing common law position in relation to the non-apportionability of rent over time should be abandoned, or, moving even closer to home, that the long-standing construction of Section 2 of the Apportionment Act should be departed from, because, as the President noted at paragraph 42, under the heading the general law on apportionment, the arguments discussed so far have focused on the terms of the lease. However, it is also necessary to consider the established legal background against which the lease was entered into, and in particular the general attitude of the law to the apportionability of rent payable in advance. Now, the common law rule in that case has its roots, the court noted, in jurisprudence of considerable antiquity, the rationale for which related to payments of rent in arrears on agricultural land, where the lessee is going to work the land, sell the produce, out of which, at the end, he will pay the rent. That is the rationale as set out in William Clun's case, Additional Authorities, tab 33, which is cited at paragraph 43 by the President. Now, obviously, that rationale has no application in practice to modern tenancies, and no even theoretical application to the prevalent type of lease where rent's payable in advance. As to the statutory position, in the alternative, the claimant in that case argued that Section 2 should, in 2015, be construed in a way contrary to that held to be correct by the Court of Appeal in a case decided in 1900, Ellis and Rowbotham, and followed since that time, so as to include within its scope not only periodical payment of rent made in arrears, but also periodical payment of rent made in advance, and one sees that at paragraph 44. And as to that, as a matter of construing the words of the statute, as I indicated earlier, the President noted at paragraph 45, and now I do start reading, excuse me, 5 lines in, middle of the line, I would not have regarded the issue as altogether free from doubt. in the light of the very wide words of the section 2, that all rents and annuities, the emphasis is in the original, shall be considered as accruing from day to day. So at first blush, the argument, the construction argument that the claimant was raising seemed to have very strong foundation. By contrast, of course, the construction proposed by the respondent's argument, particularly its new argument, involves rewriting sections 2 and 5 to exclude all periodical payments in the nature of income which are payments of salaries, not to mention, we say, as the logical corollary, excluding periodical payments in the nature of income, as Lord Justice Elias put it, wholly removed from the employment field. But for present purposes, a key passage is in the same paragraph between C and D, a sentence beginning towards the end of the line, I find it difficult to accept. I find it difficult to accept that this court could properly rule that a statute had a meaning which we thought was simply wrong, however long that meaning had been assumed to be correct. Nonetheless, I consider that in a case, one might say even in a case, where we had real doubt as to the correct meaning of a statute, we should favour the meaning which has been generally assumed to be correct for a long period, especially when the basis of that assumption is a judicial decision. That observation, we say, is germane no less to why we respectfully disagree with the Court of Appeal's decision in this case than it is to why we ask the court to reject the respondent's new argument. And then one turns to the conclusions on the next page, paragraphs 50 to 51. There's little point in resolving the hypothetical question whether in the absence of the points discussed above, the ones I've just referred to, by reference to the settled position at common law and as a matter of statutory construction. So little point in resolving the hypothetical question whether in the absence of that I would have concluded that a term should be implied as the claimant contends. Even if I would have reached that conclusion, I consider that it could not have stood once one faced up to the clear and consistent line of judicial decisions which formed the backcloth against which the terms of the lease and in particular the provisions of the relevant clause were agreed. Save in a very clear case indeed, it would be wrong to attribute to a landlord and a tenant, I interpose any more to an employer and a salaried employee, particularly when they have entered into a full and professionally drafted lease. This was a collectively agreed document that runs to certainly dozens of pages, the red book. An intention that the tenant should receive an apportioned part of the rent payable and paid in advance when the non-apportionability of such rent has been so long and clearly established. Given that it is so clear that the effect of the case law is that rent payable and paid in advance can be retained by the landlord, save in very exceptional circumstances, and these are the words I quoted earlier, e.g. where the contract could not work or would lead to an absurdity. And that is why I hesitated in answering one of my Lord Wilson's questions in the way it was initially put. Express words would be needed before it would be right to imply a term to the contrary. And then he turns to the hard facts nature of the case in front of him. I accept that refusing to accede to the proposed implied term in this case can lead to the operation of the clause having the somewhat curious effect discussed. However, while the difference in result, and it's neatly summed up here, that the difference in result between the tenant paying almost £1 million before or after the 25th of December can fairly be said to be capricious or anomalous, it does not begin to justify a suggestion that the contract is unworkable. And those last words expose, we say, not only the flawed basis of the Court of Appeal's decision based as it is on these hypothetical hard facts cases, but also of a submission central to the respondent's case and particularly to its new case. And I have in mind, though I don't ask the court to turn it up, paragraph 34 of its printed case at page 122, that if the natural and settled construction of the deeming provision in section 2 might, in its words, create new injustice, then an alternative construction must be adopted. Not so. The common law rule, the statutory construction in this case, are equally well settled and have been the subject of an equally clear and consistent line of judicial decisions. So unless the appellant's contracts, in my lady and my lord's views, could not work or would lead to an absurdity, then express words would be needed to infer this contractual intention to the contrary, and of course that's not the position. There is no feature of the appellant's contracts, either in their language or the supposed inequity entailed by the application of the settled statutory construction, which presents half so strong an argument for overturning that settled law as existed in the Marks and Spencer's case. And I do ask the court perhaps to reflect that it's difficult to identify a logical basis on which this court could overturn the common law rule and statutory construction in relation to the non-apportionability over time of salary payments paid in arrears, while resisting the invitation to overturn the common law rule as to the non-apportionability over time of rents paid in advance. The latter rule is less defensible in principle today than the former. And in the modern context, rents are quite naturally seen as apportionable from day to day, absent the Act, whereas the proper contractual apportionability of salary payments is not nearly so obvious as, let's face it, the arguments in this case rather demonstrate. And it's this supposed... It's the conflation, really, of the two categories of worker that the respondent wrongly identifies in its historical analysis that I've referred to, that underlies a confused analysis, we say, of the appellant's case in this action and of their contracts. And as to the appellant's case, I want to distinguish clearly two propositions. The first is this, that the appellants are paid to perform an integrated and interdependent set of duties, some during directed time and others, including the same types of work, during undirected time. That's proposition one. The second proposition I quote from my learned friend's printed case, that the appellants were engaged and paid to work for the respondent for each of the 365 days of the year. That is what they say our case is. Now, the first proposition is the one on which our case actually rests and which we submit to be obviously right. The second is just erected as an Aunt Sally by the respondent as being its understanding of our case, and they spend almost half of their printed case knocking it down. They say it can't be right. It isn't. Neither the existence of entire contractual obligations at common law in the context of employment, nor the proper scope of the Act in relation to periodic payment of salaries has ever depended on needing to show that the worker, again I quote, works on every day of the year, or that he is, again I quote, really paid for every day of the year, whether or not they work all the year round. That wasn't the factual situation or the analysis of Lord Templeman in relation to a judge. Very expressly wasn't as understood by Mr. Justice Blake. It's not the factual situation or the analysis of Mr. Justice Scott in relation to a teacher. It wasn't the factual situation or the analysis of Mr. Justice Avery in relation to the managing director in the case I took you to in that regard. It wasn't the factual situation or the analysis of the Court of Appeal in Fasihi in relation to a sales and marketing director. And it's never been our case, as the respondent affects to presume, that, and I quote, sixth form college teachers are entering into a period of indivisible service, persisting day and night throughout the whole month. We just never argued that. We don't now. They fundamentally misrepresent the wage-work bargain. An employee is paid for the work that he does, not the days he does it on, though, of course, he can be required to perform that work at different specific times. The appellants aren't paid in respect to the work they do during directed time for turning up at college, but for performing their teaching and other duties. And they're not paid in respect to the work they do during undirected time by reference to particular days, but again for performing their teaching and other duties. And perhaps in the short time that remains, can I just take
2 minutes you've got.
One example? So the respondent is not paying the appellants to work every day of the year, so that when a teacher agrees to do additional work, it is obvious and necessary that he will be paid for it. But he's not paid for additional days, he's paid to do additional work.
Well, he is paid for additional days, isn't he? He's paid at a rate which is geared to the number of directed days that there customarily are.
Well, that's a different point.
Indeed, contractually are.
That's a different point, my lord. It has, as I say, until now been the agreed position, and as the Court of Appeal found, that if you are asked to do an extra directed time day, you will have the associated undirected time work. That is what you are being paid for. Oh, and it's obvious that if you're going to calculate the enhancement to pay, it will be done by reference to the ascertained schedule amount. And the position that the respondent relies on in its printed case of Mr. Hartley is particularly unfortunate for it. This evidence was irrelevant until the respondent's new case, but Mr. Hartley's additional work was not to be performed in directed time. It was to be performed in additional undirected time, and it's unclear on the respondent's case on what basis he would be therefore remunerated. But returning to the general case, far from it being the logic of our case as it suggested that such payment ought to exceed 195th of his salary to reflect the additional undirected work which would be generated, we've repeatedly stated, including several times in writing, that since the additional work required in undirected time is likely to increase pro rata, it's sensible that the additional payment will be by reference to the quantifiable amount of additional time. And like most of the respondents' arguments based on the contract, on analysis, it actually supports our case. Take Mr. Hartley and assume, as they do, that the additional work was to be performed on directed days. So he was to work an extra 10 days outside of term time that the principal of the college would nominate and say, these are the extra 10 days. So let's assume that. It's not right, but let's assume it. If under his contract he's impliedly being paid not for the amount of work he is contracted to perform, but rather for every Monday to Friday, all 260 of them, either as holiday or as directed time, core duty pay or whatever, then when he's agreed to undertake the additional directed time work, what happens? You only have to ask yourself the question to realise that the respondent has no answer. Either he's got to perform it on Mondays to Fridays, in which case he's already been paid for those days, unless I suppose one assumes that he's both working a whole day and on holiday a whole day, which is obviously nonsense. Or he's to perform it on weekends, rather unlikely, particularly given the contractual bar on requiring work on Sundays and bank holidays, in which case, on the respondent's argument, the appropriate additional fraction should be 101 over 260, not 1 over 195. The only analysis which avoids these absurdities and difficulties is ours, which recognises that they are paid in return for performing the duties required of their jobs, and which therefore focuses on the additional work they might agree to perform, not on the additional days on which the scheduled part of that work has to be done.
Mr. Siegel, you're only a minute over time, so well done.
I'm grateful. I'm sorry if I was speaking too quickly to try and fit in.
Slightly fast, yes. Ms. Newton? No. Mr. Linden.
My Lady, my Lords, in the light of Mr. Eagle's candid explanation of his mood on approaching the Court of Appeal, I even hearing his submissions, I approached my submissions with a degree of optimism, but let's see if I can persuade you. It may be helpful to spell out the 4 points that we're making, or the 4 arguments. The first is under the heading, the relationship between the Miles and Wakefield principle and the Apportionment Act. And there is point A, a submission that that principle does not involve the application of the Apportionment Act. But there is an alternative submission, point B, that if Miles and Wakefield is correct, particularly as to the quantum of the deduction, then the House of Lords must have proceeded on the basis that the contract determines the rate at which sums accrue, whereas the Act determines the frequency at which they do so. Now, pausing there in relation to Lord Wilson's question about paragraph 56 of the Court of Appeal's judgment, I'll attempt to be translucent in explaining our position. The point 1A was argued before the Court of Appeal by Ms. McNeill and Mr. Cooper. That's paragraph 56, and rejected by the Court of Appeal. That's paragraph 65. second heading, which we accept is a new point, the submission is that as a matter of construction, this is not an entire agreement case or a contract comprising relevant entire obligations, and it is therefore not a contract to which the 1870 Act applies. Third submission, adopting the approach of the Court of Appeal, the effect of Section 2 of the 1870 Act is to decide the frequency of accrual, but not to determine the rate of accrual. The rate of accrual is a matter for the contract to determine. That was the view of the Court of Appeal. We note that the appellants appear to accept that there is no principle of equal daily accrual, they say as defined by the Court of Appeal, and indeed positively argue that there is no such principle. We will submit that the logic of that concession is entirely in accordance with our case, because they're effectively agreeing that the contract determines the rate of accrual. The fourth submission is that the parties in this case have contracted out of the 1870 Act as they are permitted to do by Section 7. In terms of the order in which I propose to take the points, if I may, I'm going to make the submissions, I'm going to develop the points that were developed before the Court of Appeal, and fourthly turn to the new point.
Having persuaded us that you're entitled so to do.
If I succeed in so doing. Now, pausing there, the Court will already have observed that though effectively our case is four different ways of saying that the contract decides the rate of accrual as opposed to the frequency. Secondly, you will have seen that our case is that the agreement between the parties was that the claimants would be paid for the 39 term time weeks in respect of the days when they were required to be available for work, Monday to Friday, and that they were paid for 13 weeks holiday, holiday being leave from the days when they would otherwise be required to work, in other words, the weekdays. And that gives you the figure of 260. Now, third, as it were, preliminary point, much has been said by Mr. Siegel about relative injustices on our competing constructions, but in our submission, the case that we advance is inherently just. All parties like to think that, but I've got better reasons for saying that. It cannot, in our submission, be unjust for the answer to be as provided by the contract, because, of course, that is the position that the parties have agreed. Conversely, injustice would be occasioned by a solution that departed from what the parties had clearly agreed. Those are that's, as it were, preliminary points and structure. And I turn then to the Miles and Wakefield principle. You need to have handy tab 11 of the core authorities, the report starts at page 530. I don't propose to take you through lengthy passages of the decision because I imagine you've read it already or were in any event familiar with it. As I said in opening, we make two essential points: that the House of Lords appears to have reached its decision without feeling any need to rely on the 1870 Act, and hence we submit what is attributable to the day's strike is a matter for the contract to determine rather than the Act. The second point is, if that's wrong, if in fact the House of Lords had in mind the Apportionment Act, then unless they got the fraction wrong, you'll recall that they said that a deduction of 3/37 was appropriate. The case supports the submission that the contract decides what the deduction should be, whereas the Act decides the frequency of accrual. Now, as to the factual position, again, you'll be entirely familiar with that. What we know is that this case concerned an office holder described in the legislation as being paid on a fixed salary. We don't know, I think I'm right in saying, whether he was entitled to holiday pay. We do know that the salary was described as a weekly salary by their lordships, with an obligation to work 3 hours on Saturday and 37 hours during the week. We also know that the dispute actually went on for a very long time. It didn't simply concern one Saturday. It went on from August 1981 to October 1982. I draw attention to that simply because it's easy in the present case, because it concerns one day's strike action, to forget that, of course, the logic of either side's cases needs to be tested against situations where there is significantly more extended industrial action. Mr. Siegel has taken you to the relevant passages. It's true to say that Lord Irvine relied on the Apportionment Act. Mr. Sedley, as he then was, argued that the Act had no application. You've seen that the case turned on what was described as the principle of interdependent obligations.
Can we just see why the registrar was saying that the Apportionment Act had no application? Is it at the bottom of 537?
Yes, and in the speech of Lord Templeman in particular.
They used to be paid fees, and that's why it's called and then there was a hybrid period, but although it's called a salary, effectively it's payment for...
Well, there were various arguments being advanced. A key one was that the right of the employer is simply a right to set up. The employee or the officer was entitled to his weekly salary in total, and the employer was entitled to set off, by way of damages or abatement, their losses as a result of his non-action, non-work. That was the principal argument.
Yeah, thank you.
Now, the principle on which the case turned is stated in various places. I don't take you to all of the places where it's stated, but Lord Templeman, MS 552, and then 555 to 556, the principle being no work, no pay, rather than a question of abatement or equitable set-off. I should remind you of Lord Oliver's statement of the principle by taking you to the passages for two particular reasons. If you'd be kind enough to go to page 561, you will have seen at E, just above E, that where the employee declines to work at all for a particular period, and I've already said that in my judgment this case has to be approached on the basis that the plaintiff is simply withholding his services on Saturdays, then subject to the question of whether the wages or salary payable are apportionable on a periodic basis, I see no ground upon which the employee who declines to perform that condition can successfully sue. And one can see that the view might be taken that their lordships had, through that passage, firmly in mind the fact that the Apportionment Act would render entire obligations divisible. That's one analysis of the case. If you'd be good enough then to turn on to page 566, just below H, and a further statement of the principle, and you can see, turning up to 576, that the issue was an issue of the remuneration attributable to the work that wasn't done. And so we submit. There is no need for the Apportionment Act. The employee is in principle entitled to his week's pay as a result of the doctrine of entire obligations. He accepts that he is not entitled to be paid for the days on which he did not work. The question is simply one of calculation of quantum. The concept of attributable to is answered by the contract.
Where were you reading from, Mr. Linden?
My Lord, I wasn't reading. That was my submission. Now, if, however, the position is that the Apportionment Act does have a role, the question is, what role does it have? And my submission is that their lordships appear to have, if they had the Apportionment Act in mind, appear precisely to have operated on the basis that it determined the frequency, i.e. daily, but the contract determined the rate. Now, that submission is based essentially on 2 points. Firstly, my learned friend accuses us of not citing Lord Templeman on the subject of judges. Perhaps we should have, because in my submission, those passages support our case. So if I can take you to page 547.
Which 547?
I'm sorry, I'm MS 547.
Yeah.
The first observation is that it's important, with respect, to be cautious about simply adopting what is said about judges and so on. The point that was actually being addressed in the passages from D onwards was as to whether there would be any difference in principle, the principle being that of interdependent obligations, and the notion that if you don't work on a given day, you don't satisfy the condition for entitlement to pay. Would there be a difference in principle between a professional sort type of person and a workman type of person? And Lord Templeman's answer is that there would be no logical distinction between the two types of case, and you've got that at H. He was not there addressing in detail what the answer would be in any of the examples that he cited. It was, as it were, an impressionistic statement. But what one does see is that he accepted that the question would turn on the contractual position. He appears to have proceeded on the basis that the contractual position in the case of a judge would be that they could be required to work on any of the 365 days of the year. And he says at H, there is no logical distinction between a superintendent registrar who is paid a weekly salary for a 37-hour week and a municipal dustman who is paid a weekly wage for a 37-hour week. So in other words, he recognises in our submission that the issue is as to what the contract provides, what the contract attributes to the relevant period of time. So hence we submit the passage supports us. Our stance, just as was the position of the Court of Appeal, is that, of course, there may be cases where nothing is said in the contract to suggest that the approach should be anything other than equal instalments. But there may be other cases where the position is the contract shows otherwise, and that this is just such a case. Now, in that connection, my learned friend, Mr. Siegel, took you to the Sim case, Sim and Rotherham, about teachers and so on. And of course, it's very tempting to say, well, there's a teacher's case. These are obviously not secondary school teachers. They're obviously working under a different collective agreement. But isn't the position essentially the same? But my answer to that is no, not simply because there is a difference between secondary school teachers and teachers who teach in sixth form colleges, which is what this case concerns. Not simply because, as a matter of form, those teachers worked under a different collective agreement, but also because, as you will have gathered, the terms of the Burgundy Book were different and are different to the terms of the Red Book. There are similarities, but they are not identical. Now, furthermore, MS 619, the court in Rotherham, perhaps worth just taking you to that if you've got the core authorities open. (619) at B, Mr. Justice Scott, as he then was looking at a case where the collective agreement actually stated that there were no terms or relevant terms. So against B, definition of the teacher's day duties and holiday entitlement, there are no existing national collective agreements on these matters beyond that affecting the school midday break, which is set out in Appendix 7. So he was looking at a case where there were not, as we would submit, significant countervailing terms indicating that this was not a case of equal daily accrual. So that's the, as it were, the first reason why we say that the Miles case is entirely consistent with the Court of Appeal's view that the 1870 Act does nothing other than render entire contracts divisible and provide that accrual will be on a daily basis.
And by daily, you're meaning calendar daily?
Yes, I'm accepting that as it depends, of course, what one means by accrual, but if one is speaking of the frequency of accrual, I'm accepting that the frequency is calendar days. But what I'm submitting is that the rate is a matter for the contract. So what accrues on a given day, Mr. Siegel himself is accepting depends on what the parties have agreed.
So what does accrue to a teacher on a Sunday?
On a Saturday,
Or a Sunday?
nil. Nil, and on a Sunday, nil. And that is our position, as you'll have appreciated. We say we pay you an annual salary. What are we paying you for? Or what does it attributable to?
Is there anything in the contracts which say anything about taking other employment?
I think, yes, there is. I'm going to come to my contractual arguments in a moment, and I'll take you to those passages when we get to there. So, submission 1 is attributable as simply a question of contract. Submission 2 is, if the Apportionment Act applied, it simply determines the frequency of accrual. I've sought to support that by reference to Lord Templeman looking at the contract to decide the approach. But the second basis on which I seek to support it is to point out that the fraction was wrong on my learned friend's case. Unless one takes into account the contractual position, then one gets in my submission to the position that they should not have been content for 3/37ths to be deducted. The position should have been that 1/7 was deducted, because each day 1/365th accrues. He did not perform one day's work, and the consequence is he loses 1/7 of a week's pay each week. Now, my learned friend seeks to meet that by saying, well, here's a clear case of contracting out, but he doesn't do that on the basis of anything in Miles and Wakefield which achieves this result through Section 7. He took you to Cooper in an attempt to say that, well, Mr. Justice Blake was explaining Miles and Wakefield by reference to Section 7, but the passages dealing with Miles and Wakefield do not say the result was achieved by the application of Section 7.
Why 1/7?
Because there is one day where he is not.
But let us also assume that you are correct in saying that nothing accrues for a teacher on Saturday or Sunday, because they're not required to be there on Saturday or Sunday. With the superintendent registrar, they were required to be there on Saturday, but not on Sunday. So why isn't it a 6th?
Because it's my learned friend's case. I'm submitting that the answer in Miles and Wakefield was correct. The correct fraction had been identified by Lord Irvine, because the contract involved payment for 37 hours work per week. If he didn't work 3 of those hours, then he was 3/37ths were deducted. What I'm pointing out is that Mr. Siegel's case has to be that was the wrong fraction, because actually 1/365th accrued every day. There was only one day when he didn't work, and therefore only 1/365th could be deducted each week, or 1/7 as the case may be.
Is that a convenient moment?
It's convenient to the court, yes.
Well, it's obviously convenient to you, Mr. Linden, so we'll make it convenient to us too. And we look forward to hearing from you again at 2:00.